By now, it should be pretty abundantly clear that legal immigration, doing it the right way is also under attack. So one of the questions I've been getting a lot lately and, doing several consultations just about this topic each week is, what do I do if my adjustment of status application gets denied? And the answer is, it's kind of complicated because there are several policies that are simultaneously being applied that make the future very uncertain. So let's go through a couple different scenarios so that you fully understand what your options are. The people who are going to be in the best situation by far and have the most options are people who have fewer than 180 days of unlawful presence. So for example, let's say you're here as a tourist or a student, doesn't matter. You're in a lawful duration of stay. You haven't overstayed at all. And before your duration of stay expires, at some point you apply for adjustment of status. And for whatever reason, well, not whatever reason, like not fraud or crimes or anything like that, but based on this new policy memo, for whatever reason, the USCIS officer denies your application because they think they're supposed to, or it doesn't even matter what the reason is there, right? So the moment they deny your adjustment of status, the following day, you have 1 day of unlawful presence because you had no previous unlawful presence because you were in a lawful non-immigrant visa status, and before that expired, you applied for adjustment of status. Even if you were here on a 6-month tourist visa, at the end of the 6-month duration of stay, if you already had an I-485 application pending, you'll continue to be in an authorized period of stay while your adjustment of status application is pending, even if it takes like 2 years. So 2.5 years after you've entered, you're still in an authorized period of stay in this example. And then you find out your I-485 gets denied. The following day, you have 1 day of unlawful presence. So if you have fewer than 180 days of unlawful presence and no other inadmissibility issues, like no fraud, no crime, no other issues, there's a whole laundry list of them, you can, at that point, transfer your case to a consulate abroad, assuming you have an approved I-130 petition, which is typically the case in these cases. So you'll go to your USCIS interview. Typically, they'll approve the I-130 if they believe that the marriage is real or the family relationship that you're establishing, whether it's petitioning for a parent or petitioning for a child, is real, right? So you'll get an approved I-130, and then at some point thereafter, they can deny the I-485 under this policy. Once you have an approved I-130, you can transfer it to a consulate, and as long as you don't have more than 180 days of unlawful presence, the process should go pretty smoothly, assuming you're not from one of the banned countries. In that situation, it could actually take quite a while for you to re-enter the US. The way you transfer it is by filing Form I-824 to transfer the approved I-130 from USCIS to the National Visa Center, and then you would go through the ordinary consular process. I've made other videos on this. If you want to do like a deep dive or you have specific questions, you should schedule a consultation with me. Now, what if you don't leave? You'll probably receive a notice to appear in immigration court. And at that point, you can apply for the defense from removal of adjustment of status. So adjustment of status can be filed affirmatively with USCIS, but it can also be a defense from removal. Doing it that way is much more expensive, but it is a viable option, and a lot of people still apply for adjustment of status as a defense from removal, and if you're eligible, the judge should still approve your case. Now let's talk about a slightly trickier situation. Let's say you've overstayed your visa, whether it's a tourist visa or a J1 visa or a student visa, like an F1 or M, whatever. Doesn't matter as long as it's not one of the banned visas for adjustment, like crew member or fiance visa, and you didn't marry the petitioning US citizen, you married someone else, you're barred from adjusting status, generally speaking, in those situations. All the crew members out there, check out some videos I've made on that. There are some limited exceptions, but it's hard to apply those under the current policies. So let's say you have 5 years of unlawful presence. You overstayed your visa 5 years ago. Now you marry a US citizen, you apply for adjustment of status, and for a reason related to the new policy memo, it gets denied as a matter of discretion, not because of any inadmissibility reason or whatever. Now transferring that case to a consulate abroad becomes complicated because the moment you depart the US to attend your consulate interview, you trigger a 10-year bar preventing you from coming back. So before you leave, you would either need an approved I-601A, which is a provisional unlawful presence waiver, or you would have to go to the consulate interview. They would need to make a formal inadmissibility determination and say like you're inadmissible because you triggered the 10-year bar. And at that point, you would file an I-601 directly at the consular stage. If that gets approved, it waives the unlawful presence, and assuming your country isn't one of the banned countries, you can get an immigrant visa and re-enter the US as a permanent resident there. A question that I hear a lot is, well, if I've overstayed and then my adjustment gets denied as a matter of discretion, should I leave? And the question is, it depends on what you're comfortable with. My general preference, when the option is available, is to adjust status from within the United States. You tend to have more procedural and regulatory protections from within the United States. USCIS tends to follow the rules a little more than these consulates, which can kind of be like the Wild West. I would generally, for someone who's overstayed, if they can afford it, rather fight their case in removal proceedings and apply for adjustment of status than send them to a consulate abroad where they could be waiting for a couple years for an unlawful presence waiver to get approved. But that's not always the case. It is a fact-specific inquiry. There are more things to consider than just what I'm saying in this like 5 to 10 minute video. So if you have specific questions about a strategy or you're thinking about applying for adjustment of status, you should schedule a consultation with me so that we could discuss it. All right, guys, so that brings us to the end of today's video. If you want me to make more videos about this topic and do deeper dives into this new policy memo, give my video a thumbs up. It will let me know what kind of content you guys want me to make more of, and it would also help the channel grow. So as a personal favor, I'm just asking you to like the video to help me grow and to help other people see this video in their feed. If you need assistance with a specific immigration issue, I focus my practice on adjustment of status, removing conditions, and citizenship naturalization processes. And we focus on all family-based immigration, whether it's adjustment of status in the US or consular processing abroad with waivers. We handle all that stuff. It's our bread and butter. So if you need assistance with any of that stuff, you could schedule a consultation by clicking the link in the video description below. And I'll see you guys next time for another video.